Welcome to the June 11th, 2026 Legislation and Regulation Committee meeting. My name is Jessie Crowley, chairperson of the committee. Before we convene, I would like to remind everyone present that the board is a consumer protection agency charged with administering and enforcing pharmacy law. Where protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. As I facilitate this meeting, I will announce when we are accepting public comment. I have advised the meeting moderator to allot 3 minutes to each individual providing comments. We will begin with public comments for individuals attending in person. I believe we do have some public attendees in person, followed by comments by individuals participating via WebEx. To ensure sufficient time remains to complete all the committee's time-sensitive business, if necessary, I may need to reduce public comment to 2 minutes. I will make an announcement should that be necessary. This approach is necessary to facilitate this meeting. Before we get started, I would like to ask staff moderating the meeting to provide general instructions on the process for providing public comment via WebEx.
Hi, this is the moderator. If you would like to make a comment on any of the agenda items during the meeting, you may look for the raise hand icon at the bottom of your WebEx screen. And if you are joining us by calling, you may press *3 to raise your hand. Requests to comment will be called upon in the order they are received. And once your name is called out, you'll see a prompt on your screen to unmute yourself. For members of the public joining by dial-in, please press *6 to unmute yourself. You'll have 3 minutes with a 10-second warning to make your comment, and we'll be displaying instructions throughout. Thank you.
Thank you. Sorry, I lost my place. I would like to now take a roll call to establish a quorum. Jeanette, I don't believe is joining us today. KK Ja.
Licensee member present. Thank you.
Thank you. Maria Serpa.
Licensee member present.
Thank you. Nicole Tebow.
Licensee member present.
Thank you. And I'm present. Quorum has been established. Members, we have a full agenda for today's meeting. I ask everyone participating today to be respectful of the work before the board and before the committee today, rather. We encourage participation by members of the public throughout our meeting at appropriate times. The committee respectfully requests that when comments are provided, they are done so in a professional manner consistent with how the committee conducts its business. Finally, before we move to the next agenda item, I'd like to remind committee members participating via WebEx to remain visible on camera throughout the open portion of today's meetings. Members, if you need to temporarily turn off your camera due to challenges with internet connectivity, please remember to announce the reason for your non-appearance when you turn off your camera. Finally, I would like to ask staff to send out a link to all board members when the live stream of the meeting is available. This will ensure members that are interested in having an opportunity to review the meeting prior to the next board meeting have the opportunity to do so. Thank you. Agenda item 2, public comment on items not on the agenda or agenda items for future meetings. Moving to our first agenda item, public comment on items not on the agenda, I would like to remind everyone that the committee cannot take action on these items except to decide whether to place them on an item for a future agenda. Members, following review of public comments for this agenda item, I will ask members to comment on what, if any, items should be placed on a future agenda. As a reminder, this agenda item is not intended to be a discussion, but rather an opportunity for members of the committee and members of the public to request consideration of an item for future placement on an agenda, at which time discussion may occur. Are there any members of the public in Sacramento that would wish to provide public comment for items not on the agenda?
No public comment on this item. Thank you.
Great, thank you. Moderator, we're ready for public comment via WebEx for individuals requesting items not on the agenda.
This is the moderator. If you would like to make a comment on agenda items not on the agenda, you may look for the raise hand icon at the bottom of your WebEx screen. We are displaying instructions and we'll give you a moment. See no comments, I return the floor back to you, Chair.
Thank you, moderator. Moving to agenda item 3, approval of the April 29th, 2026 draft minutes. Members, does anyone have any questions or comments on the draft minutes from April 29th, 2026? I would also entertain a motion if you believe such action is appropriate.
Hi, Jesse. This is Nicole. I'll motion to approve the minutes.
Thank you, Nicole. I will second Nicole's motion. With a motion and a second on the floor, I will open the discussion for public comment on the April 29th, 2026 draft minutes. Sorry, go ahead, Anne.
Yeah.
No
No, it
public
was-
comment on this item in Sacramento.
Great, thank you, Anne. I think we're ready for public comment via WebEx. Sorry about that.
Thank you, no worries. If you would like to make a comment on agenda item number 3, you may look for the raise hand icon at the bottom of your WebEx screen. We are displaying instructions and we'll give you a moment. See no comments, I return the floor back to you, Chair.
Great, thank you. Okay, so moving on to agenda item 4. There are several measures on today's agenda.
I apologize for the interruption. Would you mind just doing a quick roll call vote for us, please?
Oh, yeah, sorry about that. I missed that. KK, how do you vote?
Yes.
Thank you, Maria.
Yes.
Thank you, Nicole.
Yes.
Thank you, and I vote yes, the motion passes. Moving along too quickly. Moving on to agenda item 4, there are several measures on today's agenda for our discussion. May 29th was the last day for each house to pass bills introduced in their respective house. July 2nd is the last day for policy committees to meet. August 14th is the last day for fiscal committees to meet and report bills to the floor. August 31st is the last day for each house to pass bills, and September 30th is the last day for the governor to sign or veto bills. I provide these deadlines for your awareness and to help guide our work as we move forward. The meeting agenda and materials identify pending measures that impact the practice of pharmacy, the board's jurisdiction, or board operations as identified during the development of this meeting's agenda. I note that a few measures previously considered by the board did not make it out of committee or their respective house for this year. As such, those measures were not included on the agenda and will not be discussed. There is also one new measure for our consideration today. Members, do you have any questions or comments before we proceed? Hearing none. Assembly Bill 910, Pharmacy Benefit Management. The first measure for our consideration is AB 910. Members, this measure requires that the Department of Healthcare Access and Information, HCI, to include prescription drug pricing and payment data into its annual healthcare report and to notify the Department of Managed Healthcare, DMHC, if a pharmacy benefit manager, PBM, fails to comply with specific requirements. The measure also requires DMHC to post links on its website to analyses and reportings published by HCI. In April, the board established a support position on this measure. Since the April board meeting, this measure has been referred to the Senate Health Committee. Members, I believe the board's current support position remains appropriate, and I welcome your thoughts on the measure. And I'm sorry, I can't see anyone, so if anyone does have their hand raised, you can just speak up. Perfect. Hearing none, I think we're ready for public comment in Sacramento.
There's none.
Great, thank you. We're ready for public comment via WebEx.
This is the moderator. If you would like to make a comment on this agenda item, you may look for the raise hand icon at the bottom of your WebEx screen. If you are a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. Seeing no comments, I return the floor back to you, Chair.
Great, thank you, moderator. Members, Assembly Bill 957 would prohibit a pharmacy from selling cigarettes or tobacco products. As noted in the prior discussion, the policy goals of this measure appear consistent with the board's policy statement, including in the meeting materials. This is a 2-year bill that was granted reconsideration in July 2025 by the Senate Business, Profession, and Economic Development Committee. I note that the measure has not moved since reconsideration was granted last year. Members, the board established a support position on this measure. I believe the board's current support position remains appropriate, and I welcome your thoughts. Hearing none, we're ready for public comment in Sacramento.
There's none in Sacramento.
Thank you. We're ready for public comment via WebEx.
As the moderator, if you would like to make a comment on this agenda item, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. We do have a comment. Amy, you're going to be seeing an unmute request on your screen. Please click on that to make your comment. Thank you.
Hello, can you hear me?
Yes, we can. Please go ahead.
Great, thank you. Hello, Chair and members. My name is Amy Wolfram, and I'm here on behalf of the California Association of Zoos and Aquariums, and we use the acronym CAZA for that. The association members that I'm here representing today include the Association of Zoo and Aquarium members that are accredited institutions throughout California. I am also the California Policy Director for Monterey Bay Aquarium. So I'm here today to raise awareness of the unintended consequences associated with the implementation of California's sterile compounding regulations.
I'm sorry, Ms. Wolfram.
I'm
This is actually public comment for Assembly Bill 957 regarding cigarette and tobacco products.
I apologize. I thought this was items not on the agenda. Did I miss that already?
You did, but I'm. If you missed it, I'm happy to have you state that now.
Or I can submit an email if that's better.
Okay, that would be great. Thank you.
Okay, sorry about that.
No problem.
See no other comments. I return the floor back to you, Chair.
Great. Thank you, moderator. If there are no additional comments, we'll move on to the next measure. Members, Assembly Bill 1460 would prohibit a prescription drug manufacturer from blocking or interfering with qualifying nonprofit community health clinics' ability to buy drugs at reduced federal 340B price under specified conditions. This is a 2-year bill that had been held at the Senate Health Committee. The board established a support position on this bill, and I believe that position remains appropriate. Members, I welcome your thoughts. Hearing none, we're ready for public comment in Sacramento.
There's none in Sacramento.
Okay, thank you. Moderator, we're ready for public comment via WebEx.
Thank you. This is the moderator. If you would like to make a comment on this agenda item, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We do have a comment, and Andre, you're going to be seeing an unmute request on your screen. Please click on that to make your comment. Thank you. Andre, if you are speaking, you're still muted.
Hear me?
Please.
Can you hear me now?
Yes, we can. Please go ahead.
Great, thank you. Andre Peters, and I'm speaking in my capacity from the California Society of Health System Pharmacists. We as a society has a position of oppose on this bill for the reasons that it would be placing tremendous administrative burden on pharmacies that fall under the scope of this bill. This bill started out as a bill that we liked, and unfortunately over time it has been diluted with language that had added a lot of administrative burden to pharmacies, which the bill started out trying to prevent. It started out trying to prevent manufacturers selling 340B drugs from placing burdens on pharmacies and placing limitations that's outside the scope of the federal law. Unfortunately, because of all these changes to the bill, CSHP has needed to take the rare position of opposing this bill because it ultimately wouldn't be in the interest of pharmacies and subsequently patients. Pharmacies would literally need to add many staff members to try and meet these administrative burdens. And just one more thing, taking our staff away from caring for patients. So thank you very much for the opportunity to just voice our concerns with this bill.
Thank you for your comments.
There are no other comments. I return the floor back to you, Chair.
Thank you, moderator. After hearing public comment, do any members have any thoughts?
Hi, Jesse, it's Maria.
Maria.
I have some concerns hearing what Dr. Peters has talked about, that we may not have been able to discuss the complexity that this bill seems to have taken. And so I'm concerned about our support position. I think until we have more information, maybe we should go to a watch, but I'm not sure how that would be taken by changing positions, because we typically don't make that kind of, we usually move from a watch to a support. Going backwards is a little bit odd, but I am very concerned about our support position in light of the bill's changes. It appears that we may not know all of those changes and the impacts of those.
Would you like to make a motion?
Well, I'd like to maybe hear a little bit more from board staff as to what they're talking about, the changes are, and also from staff about how it would appear for the board to remove a support position and what are the political impacts of that.
Thank you, Maria.
Sorry, so this is Anne, and it may be appropriate to hear from Member Tebow as well on this. So actually, I will probably defer to Member Tebow first if you'd like to make some comments.
Let me verify with Corinne. We had previously, my organization had previously had a support position on this. We were a co-sponsor, so I think I'm not allowed to make statements. Is that correct?
That's correct.
Yeah, so sorry, I have to abstain.
So I will speak to kind of some of the general landscape as I understand it, but I am not an expert in 340B. So I want to own that absolutely upfront. So this bill was amended in June of 2025 and has not moved since that time. So from a 50,000 foot view, I'm not quite sure that this bill moves this year. The deadline for it is July 2nd. Having said that, if there are concerns with the measure, right, the board absolutely within its authority has the ability to, to remove its support position. It can remove its support position, but we don't necessarily have to, aggressively, take action on it. So you can certainly do that. As I read the bill, and again, really not my area of expertise at all, it would require qualifying non-hospital 340B community clinics to annually perform specified activities to ensure compliance with some of the program rules.
So Jesse, I just have a lot of questions. I'm looking at the board's or the staff's comments about the support from the Senate Health Analysis, that there are 79 organizations, including healthcare organizations, clinics, and hospitals that support, and 38 organizations that oppose. But this also may have been done before it was amended. So looks like it's just going to be without Nicole's comments. Jesse, what are your thoughts about being a little bit more cautious and going back to a watch? What do you feel?
If I could just, I'm sorry, Jesse, could I just clarify one thing? So the analysis that's linked, the committee analysis is from after the amendments. The amendments, I believe, were in June, and the Senate Health Committee analysis is in July. Should that be helpful information?
That is helpful, thank you. But and unfortunately, I didn't look at the actual analysis to see who all these organizations are, but I just have a big question mark in my mind. So I'm on the fence. Jesse, I'm not sure where you want to direct us to.
Yeah, I think we could go either way. Either way, we have to present something to the board, so I think we'll have more of robust discussion once we have more members. I think that'll give us some insight. So I'm okay either way if we want to just keep it for now and then decide as a full board if we want to change a position, or just keep it as watch now as a recommendation from the board. I don't think I personally am well versed enough to change my stance based off of the little information that I know just yet. So I'd probably lean more on to some of the other board members once we're all together. I don't know how you feel about that.
No, that sounds really great. I think you're right. We have a meeting in a couple of weeks, and perhaps there could be more background information to your committee report, so guide us a little bit more. That'd be great. Thank you.
Absolutely, no problem. Any other member comments? Okay. So Assembly Bill, 1587, prescription drug refills, prescriber notifications. Members, as amended, AB 1587 amends the conditions that the pharmacist authorities to provide emergency refills to specify that a notification to a prescriber is required only if a is identified. This measure was considered passed out of Senate Business Professions and Economic Development Committee earlier this week and was referred to Senate Appropriations Committee with a recommendation to place on the consent calendar. At the April board meeting, the board elected to watch this measure. I believe we should continue to watch this measure, but I welcome any thoughts that members have.
Jesse, did we ever find out what they were trying to do, what the point of this? Because I remember this one initially just had a lot of overlap with what we could already do. It sounds like they found that out and amended it, but I still don't understand why it exists or what it's trying to accomplish.
That's a great question, Nicole. I'm sorry to put Anne on the spot, but I think I'm going to have to defer to her on that.
Yeah, so right, not the sponsors or anything, but it's my understanding that the intent was with the most recent amendment was to just make it explicitly clear that, if you didn't have the prescriber's name, you could continue to do it. I can't speak for the author's office or the sponsors in this matter, but I think that some of the drive behind it was that perhaps pharmacists were not aware that this authority existed, and then maybe caused some question about maybe how to operationalize. So providing this amendment provides a little bit of clarity to help pharmacists feel more comfortable using the authority.
Thank you, Anne. Nicole, does that help?
Yeah, I'm fine with staying with a watch. I just still didn't understand why this existed. Thank you.
Thanks, Nicole. If there are no other comments from members, we're ready for public comment from individuals in Sacramento.
There is no comment in Sacramento.
Great, thank you. Moderator, we're ready for public comment via WebEx.
Hey, this is the moderator. We do have a comment. Stephen, you're going to be seeing an unmute request on your screen. Please click on that to make your comment.
Thank you for the opportunity. I think the executive officer made a very good point. There was actually legislation introduced in the last couple of years that would mandate, if it would pass, that the Board of Pharmacy collect data on every single time that the benefits to the patient of Section 4064 were not used by a pharmacist. In other words, patients were being denied refills of their prescriptions because the pharmacist didn't know or didn't use 4064, which allows them to provide a refill when the prescriber is unavailable. And that is very unusual. Across the country, there are very few pharmacy laws that allow pharmacists to do that. But we've had this particular section for over 3 decades, I believe, in California law. And I think some of the problem is that some of the large organizations that are based outside of California don't realize that pharmacists can do this in California. And so that's why the PICs and the pharmacists that work for those organizations were not providing emergency refills. Now, this is not an emergency refill pursuant to a declaration of a disaster. This is when a patient who is on, let's say, diabetes medication, there's no refills, and the pharmacist knows full well that that patient needs to be on that the rest of their lives. Then this section of the law basically said that you could use professional judgment and go ahead and make that decision to give a full quantity refill if it was a non-controlled substance. But it had a clause in there that basically said you had to notify the prescriber. And so they were using that as an excuse. Well, if I don't know who the prescriber is, or I can't reach them, then I'm not going to do the refill. So this bill was to remove that doubt and allow pharmacists to use their professional judgment to go ahead and issue those refills and this one, there's a corresponding section in the Health and Safety Code regarding controlled substances, but this particular section is all about non-controlled substances. So I encourage the board to support this. This is very important for patients to get the refills they need for urgent medication, not only chronic medication, but let's say birth control pills or something that they really need, and you don't want them to go without and have an unintended pregnancy. So I encourage the board to change its position and support this. Thank you.
Thank you for your comments.
I see no other comments. I turn the floor back to you, Chair.
Thank you. Sorry. Having heard public comment, does anyone have any additional comments?
Just I raised my hand. I don't know if you can.
Oh, sorry,
see.
KK, I can't
No
see.
problem. I have a question for possibly Anne. Are we at a stage where we can add something to 1587 or suggest something? If prescriber is not known or if prescriber is not reachable, is the pharmacy prescribe? Is a pharmacist prescribing on her own capacity? And at that point, should they be transmitting that prescription as pharmacist prescribed prescription, or should they carry on with the old prescriber whose consent or notification hasn't happened?
So KK, I think that probably goes pretty far well beyond my legal knowledge. So I'm going to own that up front. I think that the intent is to keep it pretty, I think that the author's intent is to just make it, make a simple change to just say that you only have to do it if a prescriber is identified. It's not seeking to create any additional requirements or make any additional changes. As I understand it, I think maybe some of the questions that you might be asking might be more about like how to operationalize the requirements and the provisions. And that might be like a separate discussion from the bill itself. I don't know that I'm making sense, but hopefully you're kind of understanding what I'm trying to say.
Yes, ma'am. My concern comes from that point of view, that how to operationalize it, because 10 months, 12 months down the road, if this prescription is selected for audit, pharmacist did not notify the prescriber did not authorize it. So in the prescriber blank should be pharmacist's name, as I prescribed this, for example, lisinopril, which is a blood pressure medication and non-control, or should it be a previous prescriber, again, which we are not notifying or contacting? It'll be a good question to know, or good answer to know if we have to operationalize it.
So at the staff level, happy to take a note for this to potentially be a future agenda item.
And KK, to add to what you're saying, it's complicated because some insurance companies do not recognize pharmacists as providers, so they're not going to pay for it. And Medi-Cal is requiring everyone to be signed up with Medi-Cal. So even in California, where we are providers, it would be denied for coverage if signed by a pharmacist who wasn't signed up. So yeah, no, very good point. But I think listening to what Stephen Gray was bringing up, that was very helpful, very good context. This almost sounds like it is a knowledge issue for pharmacists more than just necessarily a law issue. So separate from this, maybe this is a topic we want to bring up in the communication and public education as a piece to flag for pharmacists or do an FAQ about, or something, so that pharmacists maybe feel more comfortable. My sense is that pharmacists don't feel super comfortable using this, and maybe that's what this is trying to solve.
My personal experience is slightly different. I've seen pharmacists using their judgment and being their supervisor. Sometimes they have notified me as well. Albeit it's very rare, but it has happened, especially for birth controls and stuff like that. But operationalizing, your question was part 2 of the question. I specifically refrained from asking it because I knew that's going to be whenever we discuss the first part that we talked about. So it'll be great to know, because I think if it cannot be operationalized meaningfully, or it increases the cost of medication for the patient, then it just really doesn't help the patient either.
Great. Thank you all for a great discussion. I think these are all good points. I will say in my experience, I don't think many pharmacists do feel comfortable enough. So I think part of it is the education piece of empowering pharmacists. So I'm sure Anne will take notes, and hopefully they'll have that conversation in the communications committee meeting. And if we don't have any additional comments, I can move on to the next measure. Assembly Bill 1773, Pharmacy Benefit Managers. Members, as amended, AB 1773 requires the Department of Managed Healthcare to maintain a public website displaying specified information for each licensed pharmacy benefits manager, including, among other things, the legal name, license number, and license expiration date. In April, the board established a support position on this measure. Since the April board meeting, this measure has been referred to the Senate Health Committee. Members, I believe the board's current support position remains appropriate, and I welcome your thoughts on the measure. Hearing none, we're ready for public comment in Sacramento.
There is none.
Thank you. Moderator, we're ready for public comment via WebEx.
This is the moderator. If you would like to make a comment on this agenda item, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions, and we'll give you a moment. See no comments, I return the floor back to you, Chair.
Thank you, moderator. Members, Assembly Bill 1775 extends the current expedited licensing process for veterans to also cover service members who were discharged solely because of the federal action to restrict military service by transgender individuals, not just those who were honorably discharged. The May 18th, 2026 amendments to the measure provide authority for the Department of Veterans Affairs to promulgate regulations. This measure will be considered by the Senate Business, Professions, and Economic Development Committee on June 15th, 2026. In April, the board established a support position on this measure. Members, I believe the board's current support position remains appropriate, as the board has historically supported measures that impact licensure access for military members, veterans, and military spouses, and I welcome your thoughts on the measure. Hearing none, we're ready for public comment in Sacramento.
None in Sacramento.
Thank you. We're ready for public comment via WebEx.
Hi, this is the moderator. If you would like to make a comment on this agenda item, you may look for the WebEx screen. We are displaying instructions, and we'll give you a moment. No comments, I return the floor back to you, Chair.
Great. Thank you, moderator. Members, Assembly Bill 1778 removes testosterone from California's Schedule III controlled substances list automatically if the federal government removes it from its scheduled controlled substance list without requiring separate state legislation. Following the release of the committee meeting materials, this measure was amended to also add dihydrotestosterone to the provisions and specifies that the automatic removal from California's schedule only applies if the federal reclassification is less restrictive than California's Schedule III. This measure will be considered by the Senate Public Safety Committee on June 16th, 2026. Members, I believe the board's current support position remains appropriate, and I welcome your thoughts on the measure. Hearing none, we're ready for public comment in Sacramento.
None in Sacramento.
Great, thank you. Moderator, we're ready for public comment via WebEx.
Hi, this is the moderator. If you would like to make a comment on this agenda item, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. Seeing none, I return the floor back to you, Chair.
Thank you, moderator. If we have no additional comments, I'll move to the next measure. Assembly Bill 1794, Pharmacy Enteral Products. Members, as amended, AB 1794 authorizes a pharmacist, manufacturer, or wholesaler to participate in an arrangement or agreement to deliver enteral nutrition supplements or replacements directly to a patient's resident, pursuant to a valid order from a prescriber acting within their scope of practice. This measure will be considered by the Business, Professions, and Economic Development Committee on June 15th. You will note that the board did not establish a position on this measure. I continue to believe a position is not appropriate at this time. Members, I welcome your thoughts or comments. Hearing none, we are ready for public comment in Sacramento.
None, thank you.
Thank you. Moderator, we're ready for public comment via WebEx.
Hey, this is the moderator. If you would like to make a comment on this assembly bill, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments, I return the floor back to you, Chair.
Great, thank you, moderator. Assembly Bill 1811, Health Professional Shortage Areas. Members, in its current form, AB 1811 defines health professional shortage area until January 1st, 2035, to include areas designated by California's Department of Healthcare Access and Information, areas federally designated by HHS, and those federally designated on January 1st, 2025, even if no longer federally recognized. As such, this measure ensures areas proposed for withdrawal post-2025 remain eligible for state prioritization and benefits. This measure is currently awaiting consideration by the Senate Health Committee. In April, the board established a support position on this measure, while also offering technical amendments to clarify its application to pharmacies as defined health professional shortage areas. Members, I believe the board's current support position remains appropriate, and I welcome your thoughts. Hearing none, we're ready for public comment in Sacramento.
None in Sacramento.
Thank you, moderator. We're ready for public comment via WebEx.
Thank you. This is the moderator. If you would like to make a comment on this assembly bill, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments, I turn the floor back to you, Chair.
Great, thank you, moderator. Assembly Bill 1854, Legally Protected Healthcare Activities. Members, AB 1854 expands California's protections for people who provide, support, or receive certain protected healthcare services, such as reproductive care or gender-affirming care, regardless of this patient's location. Additionally, as amended, the measure specifies that California companies that provide financial services may not disclose customer information to law enforcement in another state unless the request includes a specific affidavit required by California law. In April, the board established a support position on this measure. Since the April board meeting, this measure has been referred to the Senate Rules Committee for assignment. Members, I believe the board's current support position remains appropriate, and I welcome your thoughts. Hearing none, we're ready for public comment in Sacramento.
None in Sacramento.
Thank you. Moderator, we're ready for public comment via WebEx.
This is the moderator. If you would like to make a comment on this assembly bill, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See none, I return the floor back to you, Chair.
Okay, thank you, moderator. Assembly Bill 1887, Prescription Drug Coverage for Rare Diseases. Members, AB 1887 is a new measure that has not been considered by the committee and the board previously. As amended, AB 1887 requires health plans beginning January 1st, 2027 to make a decision on prior authorization requests for rare disease drugs within 30 days. This applies when the drug is prescribed by a specialist familiar with the condition and who determines the drug is medically necessary. If the plan hasn't rendered a decision by the end of the 30-day period, the request is automatically approved unless there is an ongoing dispute. These requirements do not apply if a lower cost biosimilar or generic is available. The measure also prohibits plans from using step therapy for these drugs in any policy issued, amended, or renewed on or after January 1st, 2027. It's important to note that these provisions do not apply to Medi-Cal managed care plans. This measure passed out of Assembly and was referred to Senate Rules Committee for assignment on May 28th. I agree with the board staff recommendation to watch this measure. Members, I welcome your thoughts on this measure and would also entertain a motion to recommend establishing position if you believe such action is appropriate.
Hey, Jesse, it's Nicole. I'm leaning more towards support because, I mean, 30 days is a long time. And a lot of these conditions in that amount of time could become significantly worse. These are really like serious conditions. So from a patient safety perspective, I lean more towards support. But I'd be interested if other people feel differently.
Thank you. I also thought 30 days was a long time. I'd be curious to hear other people's thoughts and maybe even public members' thoughts on that as well.
Hi, it's Maria. And actually, the 30 days part wasn't the part that actually focused my attention. It was the issues of exempting Medi-Cal managed plans and not including step protocols. And I certainly want to hear more about those kinds of issues before taking a support position. So I agree with the staff's position of watch and look, and maybe we can talk about it more at the general board meeting.
Thank you, Maria. Any thoughts, KK?
Same exact. I need to have more information. Maybe we can put more collective minds to that in the general meeting.
Perfect.
I don't lean one way or the other.
Okay, thank you. I think we're ready for public comment. Do we have any public comment in Sacramento?
No.
Great, thank you. We're ready for public comment via WebEx.
Hi, this is the moderator. If you would like to make a comment on this agenda item, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. No comments. I turn the floor back to you, Chair.
Thank you. And I'm sorry I lost my place. That's what I get for having an old iPad.
I did it yesterday in my committee. Jesse Ann was panicking, so not just you.
Oh my gosh, this is like the third time in this meeting, but luckily I've been able to catch up most of the time.
Although this committee might be the worst one to do it in because it's so.
Okay, good. We're back. Okay, so Assembly Bill 1930, legally protected healthcare activity, inquiries, investigations, subpoenas, or summons. Members, in its current form, AB 1930 would stop any person or business in California from giving information to another state about legally protected health activities unless specified conditions are met. including that the request must include an affidavit stating under penalty of perjury that the investigation involves an act that is actually illegal under California law, and it must identify the specific California law that was violated. The Attorney General will be responsible for enforcing these provisions and must receive notice of the request within 7 days of receipt. As amended, the 7-day notice period for individuals participating in the address confidentiality program administered by the Secretary of State does not begin until the person is in receipt of the investigation subpoena or summons. In April, the board established a support position on this measure. Since the April board meeting, this measure has been referred to the Senate Rules Committee for assignment. Members, I believe the board's current support position remains appropriate, and I welcome your thoughts. Hearing none, we're ready for public comment in Sacramento.
None in Sacramento.
Thank you. Moderator, we're ready for public comment via WebEx.
This is the moderator. If you would like to make a comment on this assembly bill, you may look for the raise hand icon at the bottom of your WebEx screen. And if you are a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See none, I return the floor back to you, Chair.
Great. Thank you, moderator. Assembly Bill 1979, Healthcare Services, Artificial Intelligence. Members, Assembly Bill 1979 was amended following the release of committee's meeting materials. The policy goals of the measure remain the same, ensuring that a licensed healthcare professional working in a health facility, clinic, physician's office, or office of a group practice exercise independent professional judgment when reviewing and approving clinical decisions that are based on the output from a clinical decision support system. Additionally, it authorizes the appropriate licensing board to seek an injunction or restraining order when violations amount to the unlicensed practice of health profession. The measure clarifies that these restrictions do not prohibit the use of artificial intelligence for non-clinical tasks that do not require professional judgment, such as documentation or automated patient notifications. The measure does not apply to pharmacies and other areas where pharmacists and advanced pharmacist practitioners may work. During our prior discussion, we noted that prohibitions contained in the measure should extend to all practice sites where healthcare providers, including pharmacists, are providing patient care services. We also noted raised concerns with the use of AI as part of 2025 Sunset Report and noted that while the board does not believe a total prohibition of the use of AI in pharmacy practice is either necessary or in the best interest of patients, and while the board believes that AI is the tool to assist a pharmacist in making clinical judgment, the board stands firm that AI cannot and should not supplant such clinical judgment. The policy goals of this measure align with the board's position. In April, the board established a support if amended position on this measure to ensure the prohibitions extended to all pharmacists and advanced pharmacist practice sites. Since the release of the meeting materials, this measure has been referred to the Senate Privacy, Digital Technologies, and Consumer Protection Committee and the Senate Health Committee. Members, it is my understanding that while the author's office did not accept our amendments, it appears they may be open to considering the board's policy recommendation potentially in a separate measure in the future. Members, I believe the board's current support if amended position remains appropriate, and I welcome your thoughts. Hearing none, we are ready for public comment in Sacramento.
None in Sacramento.
Thank you. Moderator, we're ready for public comment via WebEx.
Hey, this is the moderator. If you would like to make a comment on this assembly bill, you may look for the raise hand icon at the bottom of your WebEx screen. And if you are a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments, I return the floor back to you, Chair.
Great, thank you.
Jesse,
Oh, sorry.
before you
Go
move
ahead,
on,
Maria.
I just wanted to state for the record that I'm hoping that those organizations that oppose this bill would speak at the board meeting as to why they oppose them. I was very curious when I looked at the list of opposition. That was all. Thank you.
Assembly Bill 1990, Pharmacy Law, Compounded Medications, Consumer Protection. Members, in its current form, the measure declared legislative concerns about unsafe or illicit active pharmaceutical ingredients entering the compounding supply chain, particularly amid high demand for weight loss drugs. It prohibits selling or distributing compounded drugs containing certain GLP-1 or related substances used for obesity or weight management, unless the compounder takes specified actions, including ensuring that the bulk drug substance is a pharmaceutical grade product and meets specified requirements. Manufacturers and wholesalers must also provide written verification to purchasers that bulk drug substances sold for this purpose meet specified requirements. The bill makes violation of its provisions subject to license revocation and fines of $1,000 per dose of the illegally compounded drugs sold, transferred, or distributed. The measure further requires specified record keeping, authorizes board inspections of compounders and suppliers, and prohibits misleading advertising of compounded weight management drugs. The measure includes proposed disclosure requirements regarding potential side effects, adverse reactions, and other warnings associated with active ingredients in its medication, unless the advertiser can demonstrate that a particular disclosure is not relevant to the compounded drug. Further, as we noted during our prior discussion in the bill's provisions do not apply to physicians and surgeons. As we discussed, it is concerning that the measure does not apply uniformly across all settings where GLP-1 compounding occurs, as such as physician offices and medical spas. Board staff have encountered significant patient safety issues in these environments during inspections and investigations, but often lack the authority to intervene, and staff believe patient safety gaps will persist unless the requirement apply to all compounding and advertising settings. During its prior discussion, the board also noted the penalties established by the measure, i.e. assessment of a fine of $1,000 per dose of illegally compounded drugs sold, transferred, or distributed, as well as revocation of the person or entity's license, remove the board's ability to assess the facts of an investigation to determine the appropriate outcome consistent with its consumer protection mandate. As noted in our prior discussion, some requirements in the bill already exist under federal law, USP standards, or existing board regulations, while others go beyond the current standards. Consistent with the board's discussion following the April board meeting, President O and board staff met with legislative staff to convey issues identified by the board. It is my understanding that the author's office appears agreeable to addressing the board's concerns related to current provisions limiting board's enforcement discretion and appears agreeable to ongoing discussion. Following the release of the meeting materials, the measure was referred to Senate Business, Professions, and Economic Development Committee and the Senate Judiciary Committee. At the April board meeting, the board elected to watch this measure. I believe we should continue to watch this measure, and I believe it's appropriate for board staff to continue to engage with the author's office to address safety concerns and issues raised. Members, I welcome your thoughts and comments on the measure, including if you believe we should continue to watch the measure or recommend establishing a position.
Hi, Jesse. It's Nicole. This one I was leaning towards oppose, and I still am. It feels weird to me to call out one particular class of drugs, and after we spent all that time, coming up with our compounding regulations, to imply that one class of drugs has to have extra things beyond that when we spend all the time, it's still not sitting well with me. Isn't feeling the same. I would like to at least raise that to the whole board. If others are kind of in agreement with that today, I would be willing to motion to oppose, but I'd like to hear if anyone else is in that camp.
Yeah, I would like to have more members discuss that. I also feel the same way for one particular kind of or a class of a drug to be singled out, even though it may have certain percentage of market share nowadays, and it significantly large chunk of total drug spend in the country.
Thank you, Nicole. Thank you, KK. I agree with you, Nicole, in that I think it needs to apply uniformly to all drugs. I do appreciate that the author's office is has been engaging with us, and maybe we can have staff work with them to raise that issue too, if they're amenable to that. I think their openness makes me more lean towards watch, because I don't know how it will evolve as we continue working with them. Maria, any thoughts?
The only thing I would add is I would just want to clarify our thoughts. I think that while we're using theoretical examples of, why is it only applying to one class of drugs versus all of them, I do not advocate for having any additional burden or regulations or removing ability to compound medications for any group of medications. So if they were to make any amendments to add more medications, I would be even more opposed to it. So I agree with staying as a watch, just so that we could have some nice discussions with the author's office rather than coming across as being adversarial. But I think we should be ready to go to an opposed position quickly if needed.
Okay. Any final thoughts, Nicole, before we open it up to public comment? And we can also raise this issue again once we go to the full board as well.
I agree with Maria. Even though I'm calling it out as being one drug, I don't really want to put more after all that work we did. We got a lot of feedback where people were already really concerned, and concerned about being able to meet those requirements. And I just don't feel like there's a good justification for going. I know I should know this, but can either you, Jesse, or someone in the room remind me, we can move to an oppose if the whole group wants to in the full meeting, right?
Yes.
Without us having proposed it here. Yeah, okay.
Yes.
Thank you. Thought so. It's been a long day. Thank you.
If there are no other member comments, we're ready for public comment in Sacramento.
We do have one.
Thank you.
Good afternoon, Chair Crowley and other committee members. I appreciate the opportunity to address the board again. My name is Marie Kottman, and I have practiced as a compounding pharmacist for more than 20 years. I respectfully urge you to change your position on AB 1990 from watch to oppose, and I hope that you'll actually read the text of the bill. I have worked alongside the board for many years through multiple rounds of rulemaking designed to ensure quality, safety, and accountability in compounding pharmacy. Because of that experience, I am deeply concerned by the precedent that this particular bill would establish. I also appreciate the board's staff's analysis because it highlights several fundamental problems with this bill. In fact, the concerns identified by your staff are not reasons to watch the bill, they are reasons to oppose it. First, this bill creates restrictions aimed at a specific category of compounded medications rather than regulating compounding practice as a whole. Pharmacy regulation should be guided by consistent professional standards, not legislation directed at a particular drug class or a particular business model. Second, the bill does not apply equally to all settings where GLP-1 compounding and distribution occur. Physician offices, medical spas, and other locations may continue their activities that create the very concerns cited in support of this bill, while licensed pharmacies bear the burden. That is not a comprehensive consumer protection approach. Third, as staff notes, many provisions of AB 1990 already exist under federal law, USP standards, the board regulations, making much of this bill redundant. And if gaps exist, they should be addressed through the board's established regulatory process. Perhaps most concerning, your own staff analysis notes the loss of regulatory discretion. AB 1990 diminishes the board's authority in two separate ways. It replaces the board's discretion with mandatory statutory penalties, and it authorizes delegation of core regulatory functions to outside entities whose authority, qualifications, and oversight mechanisms remain undefined. AB 1990 does not address those already operating outside the existing laws. Instead, it burdens compliant pharmacies while reducing the board's flexibility and authority. For all of these reasons, I respectfully encourage you to oppose 1990. Thank you.
Thank you very much for your comments. I think that's it for public comment in Sacramento. Moderator, we're ready for public comment via WebEx.
Hi, this is the moderator. We do have a comment. Michelle, you're going to be seeing an unmute request on your screen. Please click on that to make your comment. Thank you.
Good afternoon, Chair and members. Michelle Rivas with CPHA. CPHA is opposed to AB 1990. CPHA supports patient safety and holding bad actors accountable. However, AB 1990 does not target bad actors. Instead, it imposes sweeping new manufacturer level requirements on California's licensed and highly regulated compounding pharmacies. We are especially concerned that AB 1990 also creates a dangerous precedent. By applying standards traditionally reserved for pharmaceutical manufacturers to pharmacy compounding, the bill establishes a framework that could later be used to restrict access to many other categories of compounded medications relied upon by vulnerable patients. Equally concerning is the message this bill sends to the public. Throughout the debate, proponents have repeatedly implied that compounded medications are inherently unsafe or insufficiently regulated. That is not only inaccurate, it is creating unnecessary fear among patients who safely rely on these therapies every day. Undermining public confidence in compounding could discourage patients from seeking medically necessary treatment. If these concerns are about, unsafe practices, the answer is stronger enforcement against non-compliant and unlicensed entities, not new burdens on pharmacies that are already following the law. We respectfully urge the board to take a strong position by opposing AB 1990. Thank you.
Thank you for your comments.
So we have Andre. Andre, you're going to be seeing an unmute request on your screen. Please click on that to make your comment. Thank you.
Thank you. Can you hear me okay?
Yes, we can. Please go ahead.
Yes, thank you very much. Speaking on behalf of California Society for Health System Pharmacists, and we also agree with the concerns already expressed by board members and the previous speakers about this bill. And we also would like to urge the board to oppose this bill. This bill has a lot of duplicative laws that is already in FDA and California law, statute and regulation. So it doesn't really bring anything new to the table in terms of that. I also want to point out that if you look at the law, section 41571 A5, says this law says it's unlawful to sell, distribute, or transfer a compounded drug unless the person doing it conducts and document quality control testing of any bulk drug substance prior to its use, and the name and quantity of each impurity present in the bulk drug. It also says the same language that you have to do the same for compounded drugs, so you have to repeat that test. To do this, you're going to either need to do very expensive contracting with a full chemical lab that can perform that, or you need to have your own full chemical lab. So these chemical labs are usually, it's no problem for a manufacturer. But these tests, if you're already getting it from an FDA-approved facility, it's not doable. It's not doable by the pharmacy. I also want to point out the scare tactic that this bill brings and the unprecedented discipline and penalties. There is not a single instance in the nation of this draconian type of laws where you, even if you make a minor violation, let's say you miss a T, to cross a T or dot an I, this bill will give the board no flexibility. You have to revoke that pharmacy's license. This is what this bill means, and charge $1,000 per pill. These laws are not even applied to manufacturers. Not even they have to do that. So this bill is a market share grab by a pharmaceutical company by the name of Novo Nordisk, a company that has generated hundreds of billions of net profits in 2025. So that's the power behind this bill. And this bill is intended to eliminate GLP compounding in California because no pharmacy would touch this. if they
Ten
know that
seconds.
these are the consequences for compounding GLP-1. So please help us in opposing this bill.
Thank you for your comments.
You have no other comments? I turn the floor back to you, Chair.
Great, thank you, moderator. We had pretty significant public comments, so I wanted to bring it back to members to see if you have any final thoughts.
Jesse, this is Maria. I would second if Nicole wants to make a motion. I agree with what all of the commenters were saying, and I've always agreed with it. It was more of trying to determine what is the best strategy to accomplish our end goal. But in mind of what some of the commenters have said and what we've talked about in different meetings is, I think it's important for the board to take a really strong leadership role to say that we feel confident that we are monitoring and applying compounding practices for the safety of our communities, and that any outside group that is trying to essentially bypass the board or say that the board is not accomplishing this function really we should be very vocal and say that we oppose that. So Nicole, if you feel that you want to make the motion, I'd be happy to second it.
You read my mind, Maria. Yes, I would like to motion that we move to oppose. We can still have the discussion at the whole board, but I think we set that this is where we are as a group. They made some really great points in the comments, and I'm with you, Maria. They can't dictate what the board does. They're taking away our options. Our compounders should not face higher requirements as manufacturers, things like that. So, yep, I will make the motion.
I'm sorry, this is Anne. I apologize for the interruption. I'm wondering if you might be agreeable to considering at least an oppose unless amended, given that the author's office has conveyed their willingness to continue to work with the board. That would at least allow for the dialogue to continue.
I'm pretty much adverse to that, because at first I was, trying to be, collegial, friendly, let's all kumbaya, get together and work. But when you really look at what they're trying to accomplish, what part of this proposed statute would we be happy with? And so I don't think we'll ever come to an agreement unless they choose to pull the bill. So I think at this point, one of my fears is if we say nothing, then it implies that we agree. Certainly oppose unless amended does not apply that we agree, but what could they amend that we would agree to? Repeating compounding regulations, we don't want that in law, repeating it. That's why they're in regulation. So Nicole, unless you feel strongly, I think we should go with the full oppose.
I agree with you, Maria. I did want to ask Anne, were there any amendments that we were already working on, or anything that we proposed that could wrap this up, or?
Yes, so we believe that we already have agreement with respect to the enforcement discretion piece. I think that there's agreement there with, like I said, a commitment to continue the dialogue. So I'll just kind of leave it at that. But yes, there has been agreement in some areas.
Okay, this one's tricky. I need to think for a second. Jesse,
So I
as our
support you,
chair.
Nicole, if you want to think still for a little bit, because I'm thinking that, we can create a laundry list of all the things that we want to be amended for the oppose unless amended, because it would include all the additional testing. It would include anything that tramples on or comes near to FDA requirements and regulation. When you include that laundry list, it's like, what's left? The title. I mean, that's pretty much it. I'm sorry, I got a little persnickety there.
No, it's helpful. Thank you.
There's also information about advertising and other stuff that would be left if we took out some of that stuff.
Got it.
Yeah, I was
Jesse,
actually
as our
going to
chair, I was gonna ask you.
I'm glad that she mentioned that, because I think after listening to the meeting in April, a lot of public comment from then, and even just from personal experience, seeing a lot of the advertising with these weight loss compounded products, a lot of the times it's almost advertised as an FDA approved drug, almost like like the drug manufacturers that you see. And so I understand the concern with this specific class in that sense. I think there's some good notes there. How much of that? I mean, I guess it may not necessarily be in our jurisdiction, even if it was just for advertising, but just from a patient safety perspective and the sort of information that they're consuming and on the receiving end of, I think that does make a difference to our consumers. I would lean more towards oppose if amended, because there is an open dialogue with the office. I don't know how open they are, but it sounds like we may be able to, we have the enforcement piece down. Maybe we can talk about some of the other logistical things, but I don't know if KK has any additional thoughts.
I think Maria and Nicole has captured most of the things I was thinking about. I don't think it would hurt to have more discussion and then also find the opinion, if possible, from other board members as well. Certainly would agree that we don't need to overburden the licensees in the state with the higher standards than they need to be. But again, I like to keep an open mind. I would like to hear from both sides if there is a second side available.
So I would be okay with oppose unless amended, but those amendments must include any language that conflicts or that's not just conflicts, but that steps across the line of FDA regulation and board regulations. So any of that language that has to do with the specifics of compounding that's covered by board regulation and federal law should not be in state statute.
Yeah, so basically we want oppose unless highly amended, but yeah, we'll do oppose unless amended, so we leave the door open and then we can change if we get to a point that we feel comfortable with, but it sounds like we're leaning oppose, which is what that exists for. So I will motion to move to oppose unless amended, so we're leaving that door open. And then I think what I would like to do personally is we all know the issue now. We can really think about it and we can bring what those amendments and needs might be to the board meeting, and then they can add on to that discussion. So yeah, I'll move to oppose unless amended.
And Nicole, can we just add unless amended consistent with the board's or consistent with the committee's discussion today?
As stated, yes, that's my motion.
I'll second that.
Okay. Thank you. So we have a motion and a second, so I believe we have to open it back up for public comment. Do we have public comment in Sacramento?
Yes, we do.
Cotman speaking on behalf of myself as a compounder. I appreciate you moving towards and oppose with amendments. However, the advertising requirements in here are something that as a compounder I can't legally use, because then I would be stepping on the manufacturer's toes. So I would be claiming manufacturers' research and studies and all of that sort of stuff. I do believe that this bill essentially needs to be gutted, or possibly you could confer with some of the organizations who are actually opposing this and have possibly some amendments in mind as well. Maybe that would be a collaboration that could happen. But I think you should stay with an oppose at this point in time and stay strong so that you have your autonomy.
Great, thank you. Moderator, I think we're ready for public comment via WebEx.
Hi, this is the moderator. If you would like to make a comment on this assembly bill, you may look for, or this motion, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We do have a comment. Michelle, you're going to be seeing an unmute request on your screen. Please click on that to make your comment. Thank you.
Thank you. Thank you for the opportunity to speak again. I appreciate it. Just a little something for consideration in addition to what you just heard from the last testifier. a lot of the comments that have been made around this bill and the targeting of teenage girls specifically, CPHA agrees it's inappropriate. And even though they talk about, they being the proponents, talk about marketing being a concern, the legislation doesn't speak to the fact that young girls are being targeted for use with this medication. So it's been a really good talking point for them to be able to use, and they've probably gotten a lot of votes because of it. But again, the bill does not address that specific issue. So again, I just wanted to make sure that that was something the board was taking into consideration as well. Thank you.
Thank you for your comments.
Next up, we have Andre. Andre, you are going to be seeing an unmute request on your screen. Please click on that to make your comment. Thank you.
Okay, thank you very much. Andre Peters from CSHP again. And I'm glad that the board changed the position to oppose unless amended, although I agree more with the board members that would just leave an all-out opposition. Just keep in mind, if you take an opposed position, you still have an open door to discuss it. I agree with board member Serpa. You basically have to gut this whole bill to come out with something that would be workable for California. This bill would, the way it's written now, and if some of these things remain, like the penalties and the chemical testing, it would eliminate access for patients to compounded drugs in California. Nobody in their right mind has a license would touch these drugs if they know that this is the risk associated with it. So I think I wish the board good luck with your discussions with the author. We've tried to have some discussions with him, and even though they will listen, they haven't taken a single one of the pharmacy associations in California's suggestions for change. I feel like they may appease you on a few things, but please keep in mind the bigger picture that's associated with this, which is there's not going to be compounded product for California patients if this bill passes. So thank you very much. Appreciate the opportunity.
Thank you for your comments.
No other comments? I return the floor back to you, Chair.
Great. Thank you, moderator. Any final thoughts before we go to vote? Okay, hearing none. Nicole, how do you vote?
I vote yes.
Thank you. KK?
Yes.
Thank you, Maria.
Yes.
Thank you. I vote yes, the motion passes. Moving on to Assembly Bill 2141, Pharmacies License Discipline, Stipulated Settlement and Disciplinary Order. Members, as amended, AB 2141 authorizes the board and a licensee to enter into a stipulated settlement and disciplinary order before a formal accusation is filed, provided certain conditions are met, including the licensee's voluntary waiver of administrative hearing rights under the Administrative Procedure Act and the submission of specified mitigation and rehabilitation information. A designated board committee must review this information and may extend a stipulated settlement and disciplinary order offered to the licensee. This measure was referred to Senate Business Professions and Economic Development Committee. Members, as discussed previously, between 2019 and 2021, the board explored creating an alternative enforcement model to improve efficiency of its disciplinary process. During this time, the board explored several options but never finalized development of a proposal because at the request of stakeholders, the board stopped its consideration of the matter in July 2021. You will note that the board did not establish a position on the measure, and I believe this action remains appropriate. Members, I welcome your thoughts.
Hi, Jesse, it's Maria. Thinking back to our discussion that we had at the previous committee and board meeting, I think that those comments are still applicable, but an additional thing I think we need to discuss further is that I don't think the board should remain silent. Silence is interpreted as either not caring doesn't matter or rolling over or lots of things that I don't think we are. I think we need to really show that we care about this issue and that we want to be involved with how it progresses. With that said, I have some concerns about board members that may need to recuse themselves if they're involved with settlement hearings or settlement meetings that don't move forward. So I'm concerned about the operations of the board moving forward. So I'm not in opposed. I mean, the enforcement committee was we were like this close to getting an alternative model started through the regulatory process or through the whatever process we needed. And stakeholders asked us to stop. They actually asked us to stop. They didn't say continue with you doing, they asked us to stop that discussion. So I think we need to have a position. And I'm not quite sure what that position would be. I don't think it should be opposed or opposed unless amended, because that is negative. But I'm not quite sure if it should be support if amended. So I'm curious as to what other board members say.
Any thoughts from anyone else? Okay, I guess I can add my thoughts into. Oh, sorry, was that Anne?
Yeah, I was just going to say that the language, just if it's helpful information, the language in the bill does not reflect what the board's proposal was at the time that it was, tabled, I guess is the best way to say it. So just wanted to call that out. Should that be helpful information?
Great, thank you, Anne. I would say for me, I don't necessarily see the value in the proposed disciplinary process within this bill, but I would be interested maybe to hear more information about where we were in the process when it was tabled. I don't know if you remember, Maria, I know this is putting you on the spot, but if it was something similar, do you recall?
Well, I think one of the things that we could talk about, I don't have the details at the top of my mind, but I think maybe that could be the amendments that we would look for, is to match closer to what the board was about to embark on. Board staff met with the AG's office, and they did a lot of planning and evaluation. There was a thoughtful approach that looked at all aspects of it, and that at least those discussions should be included in the proposed action. And so maybe if we do support if amended, and those amendments would include something closer to what we had before, I'd be interested to see if that's something the board would be interested in.
Thank you. I think for me personally, it's hard for me to lean one way or the other, even like a support if amended position, without having that full reference of where we had left off, especially with knowing how intensive a process it is to go through these committee meetings. So for me, I think I'm still leaning towards not establishing a position. Maybe we can get more information before the full board meeting and have a more robust discussion at that point. Any thoughts from KK or Nicole?
I don't have any definitive opinion on this. Sorry.
It's okay.
I'd like to hear more from staff, maybe at the board meeting, as to what our options are. I'm just afraid that being silent is not helpful for us.
Perfect. Yeah, we can definitely work on that together as we develop the chair report for the full board meeting. Any other thoughts before we open it up for public comment? Okay, we're ready for a public comment in Sacramento.
Yes, we have one.
Thank you.
Thank you, Chair Crowley and committee. I appreciate the opportunity to speak to you one more time. I was not planning on speaking on this, but I thought maybe hearing from a licensee may be helpful. I did actively support this bill as it went through the Assembly, and this is what I shared with the Assembly Business and Professions Committee. This was in April. I am Marie Kottman, pharmacist and former owner of Pacific Compounding Pharmacy. in Stockton, where I served thousands of patients for 20 years of ownership. I have a passion for pharmacy, especially compounding pharmacy, and throughout my career, patient safety and regulatory compliance were always my top priorities. I actively participated in the Board of Pharmacy rulemaking process, and I invested heavily in training, facilities, and procedures to meet evolving standards. However, as a pharmacist in charge, I was responsible for everything that happened in that pharmacy. And over time, the regulatory environment became increasingly difficult to navigate, especially when the rules could be interpreted differently, and there was no structured opportunity to resolve those differences early. I lived with the fear that a board inspector could interpret a rule differently than I and move directly toward formal enforcement without an opportunity to clarify or correct. As someone committed to getting it right, that risk was overwhelming. I saw ethical colleagues drawn into costly legal processes despite acting in good faith, and I ultimately sold my practice to avoid that possibility. AB 2141 offers a practical solution by creating an interim step before referral to the Attorney General. It promotes transparency, consistency, and objectivity. It allows for early communication and corrective action while fully preserving the board's authority to take formal discipline when necessary. I'm being consistent in my two testimonies to you today. Other states, including New York, Washington, Oregon, and Illinois, already use similar processes to resolve cases more efficiently while maintaining accountability. This approach strengthens collaboration between licensees and regulators, focuses enforcement resources where they are most needed, and helps preserve patient access to compounded medications. If something similar were in place a year ago, I might not be speaking to you as a former business owner. Thank you.
Thank you for your comments. Moderator, we're ready for a public comment via WebEx.
Hi, this is the moderator. We do have a comment. Stephen, you're going to be seeing an unmute request on your screen. Please click on that to make your comment. Thank you.
Thank you again. I believe that the previous speaker laid it out very well, both in the cause, the effect, and the history. This was a big problem that the board members wanted to solve, which was how to get to a legal stipulated resolution and allow everybody to move on without having to go to the delay and the expense on both the board side, the AG side, and mainly on the pharmacist side or pharmacy side or hospital side before you could reach a legal settlement, an enforceable legal settlement. There were pharmacies that went out of business, went bankrupt while we were waiting for the formal accusation and AG process. While the board had members and staff at that time were pretty much agreed with them on, well, this, if you'd make this adjustment or that change, we would all be satisfied. But they were told that there was no mechanism in California law to do that, despite also bringing forth what other states could do and had resolved that. And there are other states besides the ones that were just mentioned. Jeff Stone, a pharmacist who was the senator, called a special meeting at the county offices in Riverside, where he invited the board, the AG, and all the compounding and hospital pharmacists that were interested. And basically they said that what was being put forth mainly by the AG's office was no better than what was already there. I mean, you can have more and more discussion, but you still have to go through the AG to get a stipulated agreement. So this is a good bill, and it's good for pharmacy, it's good for the board, and it's good for the public. There ought to be a way that you can get a legal binding agreement between the board and the licensees, be they pharmacies or pharmacists, without having to go bankrupt or destroy your health, which was one of the other things that was happening, because it took months, even years, to go through the official discipline process. I encourage the board to change its position and support this, and to support it strongly. It solves a long-standing problem. Thank you.
Thank you for your comments.
Next up, we have Andre. Andre, you're going to be seeing an unmute request. Please click on that to make your comment. Thank you.
Yeah, thank you very much. Just a short note that California Society for Health System Pharmacists also has a support position. As previous speaker stated, it appears like it's providing a mechanism that is going to be both a lot more efficient and for licensees as well as for the board. Sometimes you get in a situation where some things identify, the parties both admit, all right, it's wrong, let's fix it, and then we can carry on with business. And we feel that this provides for that mechanism where if everybody agrees, then you can follow this pathway and get a resolution. Thank you very much for the opportunity.
Thank you for your comments.
You have no other comments? I turn the floor back to you, Chair.
Great. Thank you, moderator. Having heard public comment, members, any additional thoughts? Okay, maybe we'll continue this discussion at the full board meeting though and see where we land. Moving on to the next measure, Assembly Bill 2282, Health Facilities Emergency Medical Services. Oh, here we go again. Sorry, it keeps happening. Right back up. This is my sign to get a new iPad, everyone. Almost there. Here we go. So members, as amended, AB 2282 allows a general acute care hospital to get a special permit to operate an emergency stabilization unit in Patterson, Stanislaus County, a separate location not connected to the main hospital, to serve the community previously served by Del Pardo Healthcare District. This measure is currently awaiting assignment in the Senate. You will note that the board did not take a position on this measure. However, it recommended that the board staff propose technical amendments to ensure the board has the authority to issue a pharmacy license to an emergency stabilization unit if needed. Members, I welcome your thought on this measure. Hearing none, we're ready for public comment in Sacramento.
None in Sacramento.
Thank you, moderator. We're ready for public comment via WebEx.
Hi, this is the moderator. Oh, we do have a comment. We are displaying instructions in case anybody else wants to make a comment. Stephen, you're going to see an unmute request on your screen. Please on that to make your comment. Thank you.
I think this is an important measure that the board has given and should give serious thought to. I'm not familiar with the discussions at this time about these types of emergency stabilization, but I do agree that the board needs to have a sound statutory legal basis for allowing these units to buy prescription drugs and prescription devices. And it's not clear that that what is proposed would afford that. It doesn't change Business and Professions Code 4059. 4059 lists the entities that can buy prescription drugs based on their licensure or based on their, the fact that they're a physician or whatever. This would either need to be added to that, or as the board said, the board would need to be able to issue them a license, and that license would then hold them responsible for the inventory management, the record keeping, the sourcing from responsible, safe sources, and all of those things that it holds other licensed entities to for getting prescription drugs and prescription devices. So I believe it should be a support if amended official, and we either get it into a board license or get it into 4059, where it's an entity recognized in statute that can get legally from wholesalers. It's without that, the wholesaler is going to be put in an awkward position. They'll basically get an order from some of these units, and who do they list as the entity that has the license? Is it a physician with name and address, like is required, license number, NPI number, and all of that? Or what is the entity? Is it the hospital, and then the hospital redistributes it to this? And is that legal? So I think it's support if amended, and be very serious about the amendments to get the legal basis real solid. Thank you.
Thank you, Dr. Gray.
We have no other comments. I turn the floor back to you, Chair.
Thank you, moderator. Members, any thoughts after hearing public comment? Okay, hearing none, we'll move on to the next measure. Assembly Bill 2565, Medi-Cal Pharmacist Services Reporting. Members, as amended, AB 2565 requires the Department of Healthcare Services to issue guidance clarifying Medi-Cal managed care plans' obligations to cover pharmacist services. Additionally, it directs DHCS to update its model evidence of coverage to explicitly state that pharmacist services are covered and to take corrective plan action if plans fail to comply with existing pharmacist service coverage requirements or the new guidance. Following the release of meeting materials, this measure passed out of Senate Health Committee and was referred to Senate Appropriations Committee with a consent calendar recommendation. Members, I believe the board's current support position remains appropriate, and I welcome your thoughts on the measure. Hearing none, we're ready for public comment in Sacramento.
None in Sacramento.
Thank you, moderator. We're ready for public comment via WebEx.
Hi, this is the moderator. If you would like to make a comment, please click on the raise hand icon at the bottom of your WebEx screen. If you're joining us via call-in, you may press *3 to raise your hand. We have a couple of comments. Stephen, you're up first. You're going to be seeing an unmute request. Please click on that to make your comment. Thank you.
Thank you. I believe that the board should support this, support it strongly. The board has identified that the provision of pharmacist clinical services is not sustainable without an economic model that will sustain it. The board supported in the past AB 317 that put forth that the Department of Healthcare Services and other entities that are payers should be paying for these clinical services and not just for the drug dispensing and the dispensing fee. So this is basically to kind of encourage implementation, to go forward with that. Basically, all it's doing is requiring the Department of Healthcare Services to remind all those entities that they are supposed to be taking a serious look at what pharmacist services are beneficial to the healthcare and the Medi-Cal enrollees, and to pay for those services so that they can get them. This goes a long way toward equity in that other insurance companies are starting to pay for those services. People that can afford it pay for those services out of their own pocket. But this provides equity for those very important medication management services that are needed, especially perhaps by the Medi-Cal enrollee population. So I would encourage the board to take a support position. I think that is consistent with its strategic goals. It's consistent with its policies in supporting AB 317, et cetera. Thank you.
Thank you for your comments.
Next up, we have Michelle. Michelle, you're going to be seeing an unmute request. Please click on that to make your comment. Thank you.
Hi, I just want to confirm we're still talking about AB 2565, correct?
That's correct.
Okay, thank you. So CPHA is the sponsor, and I just want to thank the board for your support of this legislation. As you know, we've all done a lot of work to make sure that we're expanding access to care by granting pharmacists the authority to provide direct care to patients, but without payment, we can't implement it. So again, we just want to take the opportunity to thank the board for your support.
Thank you very much for your comments.
We have no other comments. I return the floor back to you, Chair.
Great, thank you, moderator. Moving on to the next measure, Assembly Bill 2571, Reimbursement for Pharmacist Services. Members, the measure has been amended since our last discussion. In its current form, AB 2571 provides reimbursement authority for advanced pharmacist practitioners. That does not roll off the tongue as easily for me. And pharmacists working in federally qualified health centers or rural health clinics as defined in federal law. Following the release of the meeting materials, this measure passed out of the Senate Appropriations Committee with amendments. The recent amendments revert reimbursement for pharmacist services back to the no less than 85% of the fee schedule for physician services. Members, I believe the board's current support position remains appropriate, and I welcome your thoughts on the measure. Any comments from members? Nope. Okay, we're ready for public comment in Sacramento.
None in Sacramento.
Okay, thank you, moderator. We're ready for public comment via WebEx.
Hi, this is the moderator. If you would like to make a comment, please click on the raise hand icon at the bottom of your WebEx screen. And if you are a call-in public member, you may press *3 to raise your hand. We are displaying instructions. We do have a comment. Katie, you're going to be seeing an unmute request on your screen. Please click on that to make your comment. Thank you.
Hi there, Katie Derry. I work in a larger academic system, and I fully support the intention of this bill. I do just want to call out that for those of us who work in a system where we have credentialing and privileging within our own health systems, this sets another standard where we have to do another step beyond what we already have for our credentialing and privileging within our systems to go and get this other tiered licensing system to be able to obtain that reimbursement. And so while I don't want to hold this up, I do think that that piece is something that makes it harder, especially for those pharmacists who practice in a system where you do have a credentialing and privileging system, to take more onus on getting this secondary tiered licensing status to be able to obtain the reimbursement. I just want that considered and thrown into the minutes there. I'm not necessarily saying to support as amended, but I definitely want that to be noted that some of us who work in systems where we have to go through these other processes, we would have to do double the work to be able to obtain the same outcome. Thank you.
Great. Thank you so much for your comments.
We have next up Andres. You're going to be seeing an unmute request. Please click on that to make your comment. Thank you.
Yeah, thank you very much. Andre Peters speaking on behalf of CSHP. We're also the sponsoring organization for this bill, and the bill is really intended to continue to move the needle for reimbursement that AB 317 started. The bill has two components. The one component is for health plans, and the other component is for medical. There was an amendment to initially the health plan portion said it was for advanced pharmacist practitioners, but that was amended to include all pharmacists now. The medical portion still says the advanced pharmacist practitioner. However, I want to point out that it still allows for all pharmacists to be able to bill for MTM services. So we would very much like to request the Board of Pharmacy's continued support for this bill, since it is in alignment with discussions and the directions that the board has indicated in the past. Thank you very much.
Thank you very much for your comments.
See no other comments. I turn the floor back to you, Chair.
Great, thank you so much, moderator. Members, after hearing public comment, do you have any thoughts or comments on the measure? Perfect. Before we move on to the next measure, wanted to check in with people. It looks like we may have to take a break if this goes before. So is everyone okay taking a 15-minute break and to come back at 4, or do we want to try to push through? How's everyone feeling?
We can take
Sorry,
a break. Take a break. Sorry.
Okay, we'll take a 15-minute break. We'll come back at 4 o'clock. Hi, everyone. Sorry for the delay. I was having a little bit of technical difficulties, but it's 4 o'clock. So we'll get started again. We'll do a roll call. Nicole?
Present.
Thank you. KK?
Present, ma'am.
Thank you. Maria?
Here.
Thank you. And I am here. We're ready to move on. Members, the next measure for discussion is Senate Bill 964, prescription drug coverage dose adjustments. Members, this measure was amended since our last discussion. In its current form, Senate Bill 964 authorizes a treating provider to request and dose or frequency of a drug to meet specific medical needs of their patient without prior authorization if specified conditions are met. The recent amendments provide that if the adjusted dose or frequency is for an off-label use, 2 articles from major peer-reviewed medical journals must be presented as data supporting the proposed off-label use as generally safe and effective. This measure has been referred to Assembly Health Committee. Members, I believe the board's current support position remains appropriate, and I welcome your thoughts on the measure. Hearing none, we're ready for public comment in Sacramento.
None in Sacramento.
Thank you. Moderator, we're ready for public comment via WebEx.
This is the moderator. If you would like to make a comment on this agenda item, you may look for the raise hand icon on the bottom of your WebEx screen. And if you are a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments, I return the floor back to you, Chair.
Great, thank you, moderator. 123, healthcare coverage, antiretroviral drugs, drug devices, and drug products. Members, with respect to Senate Bill 1023, as previously discussed, current law prohibits healthcare service plan except Medi-Cal managed care plans and health insurers from requiring prior authorization or step therapy for medically necessary PrEP or PEP, but allows them to apply these restrictions to other therapeutically equivalent versions as long as one option is available without restriction. Senate Bill 1023 removes that exception and fully prohibits prior authorization or step therapy for all antiretroviral drugs, devices, or drug products used for HIV prevention. Beginning January 1st, 2027, any plan that covers FDA-approved self-administered HIV prevention treatments as a medical benefit must also cover them as an outpatient drug benefit. This measure has been referred to Assembly Health Committee. Members, I believe the board's current support position remains appropriate, and I welcome your thoughts on the measure. Hearing none, we're ready for public comment in Sacramento. Do we still have a public commenter in Sacramento, by the way?
Yes, she's here, but she
Okay,
doesn't have
perfect.
a comment today on this item.
Thank you. Moderator, we're ready for public comment via WebEx.
This is the moderator. If you would like to make a comment on the Senate bill, you may look for the raise hand icon at the bottom of your WebEx screen. If you are a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments, I return the floor back to you, Chair.
Great, thank you, moderator. Moving on to our next measure, Senate Bill 1094, prescription drugs. Members, as amended, Senate Bill 1094 would allow a pharmacist to substitute a biosimilar drug, a nearly identical version of a brand name biologic drug, when filling a prescription, as long as the prescription does not include do not substitute or words of similar meaning as specified. I note that the current law authorizes a pharmacist to select an interchangeable biological product, and this measure expands those provisions to allow a pharmacist to select a biosimilar product. The measure will be considered by the Assembly Business and Professions Committee on June 23rd. At the April board meeting, the board elected to watch this measure. I believe we should continue to watch this measure as it goes through. Members, I welcome your thoughts or comment on this measure. Hearing none, we're ready for public comment in Sacramento.
None.
Thank you. Moderator, we're ready for public comment via WebEx.
This is the moderator. If you would like to make a comment on the Senate bill, you may look for the raise hand icon at the bottom of your WebEx screen. We do have a couple of comments. Stephen, you're up first. You're going to be seeing an unmute request. Please click on that to make your comment. Thank you.
Thank you. This is a very important measure. It has a very important effect on the cost of health care. The biosimilar products and the biological products are among the most expensive. Their therapy is long-term in many cases, and but they're not generic equivalents. You know, there's a difference in the molecule, and that difference may or may not be significant clinically. Actually, some of the biosimilars that were produced after the reference drug, the original trade named reference drug, ran out of its 12-year exclusivity, have shown better effect than the reference drug, the original one. This is complicated because you need to understand that when a manufacturer produces a biosimilar, they do not have to submit it for evaluation by the FDA as interchangeable. And if they believe that the drug is better and will be chosen often, if not exclusively, by prescribers, then they don't need to go down that path, which is very expensive and is also delays marketing of the drug. So we have biosimilars that have decided, their manufacturers decided not to put them through the interchangeable process, but they can still market them. Health plans and hospitals have always been able to decide which ones they want to use. Actually, this provision, this change to pharmacy law to allow pharmacists to make this decision using their standard of care, which the board has adopted, was actually in AB 1503, the Sunset Bill. It did not survive in that, and you can imagine why. There are a lot of biological manufacturers, some of them big in California, that produce the reference drug, the original one, and they put pressure to get that out of AB 1503. I believe the board has already supported the concept when it supported it in AB 1503, and I believe it should change now. It will enable pharmacists who are competent, who are comfortable, but it doesn't require any pharmacist who's not comfortable with making the interchange to actually substitute the biosimilar. But it allows those that are educated and are to make that. And it helps the patient because often the biosimilar is covered where the reference drug won't necessarily be covered. And so you're really helping the patients also. Thank you.
Thank you for your comments, Dr. Gray.
So we have Andre. Andre, you're going to unmute request. Please click on that to make your comment. Thank you.
Thank you very much. Andre Peters speaking for CSHP. And we actually have a supportive amendment on this bill. This bill has two components. The first component is the Business Professions Code, which we fully agree with, although it's not really that ground shifting for health system pharmacy because we've already been using the biological product that's in the existing language to help guide our formularies, and we have the advantage of having formularies. The second part, though, is and it's I'm not hearing any discussion, and I'm not seeing any notes on it for the committee, but that's on insurance, and we're really concerned about that. What happens is that pharmacies and health systems go and you get a contract with a particular biosimilar manufacturer, and you have to meet volume targets and things like that. And in the end, it translates to a much lower price for the health system. On the flip side, health plans do the same thing. They also go and contract with manufacturers, and they may select a different manufacturer. So when the patient shows up for their infusion, or at the specialty pharmacy where you use most of these biosimilars, the pharmacy would want to use the product we have on the shelf, and then we get informed by the prior authorization that we have to use a different NDC. The pharmacy then needs to go now and buy that different NDC off contract that impacts our existing contracts and the volume discounts we're getting, increasing our costs. So ultimately, we're unable to provide the drug to the patient at our lowest cost. And it increases our inventory as well. So the net effect is something that I think is near and dear to all our hearts, which is the abilities for pharmacies to stay open and pharmacy deserts. Because we have this inherent competition, the language in this bill that favors the health plan is once again going to be putting pharmacies at a disadvantage. And once again, we're at the losing end of the end of the chain. So it's a very unfortunate position that this bill is being masqueraded as a win for pharmacy when it's actually going to be a financial loss for the pharmacy. So please keep that in mind if you're determining a position on this bill.
Thank you, Dr. Peters.
We have no other comments. I turn the floor back to you, Chair.
Thank you so much, moderator. Members, after hearing public comment, do you have any additional thoughts or comment on this measure? Perfect. Hearing none, we'll move on to the next measure. Senate Bill 1199, Prescription Drug Cost Sharing. Members, SB 1199 requires plans and insurers, oh no, not again. Here we go. Okay, to count all payments made by or on behalf of an enrollee, including permitted manufacturer assistance, toward their out-of-pocket maximum and other cost-sharing requirements. It also establishes an administrative penalty for violation by a health insurer, enforceable by the insurance commissioner after a notice of opportunity for a hearing. As we noted in our prior discussion, this measure appears designed to benefit patients by ensuring that any financial assistance they receive for prescription drugs, such as manufacturer copay coupons or third-party assistance, counts towards their in-network deductible and out-of-pocket maximum. This measure has been referred to the Assembly Health Committee. Members, I believe the board's current support position remains appropriate, and I welcome your thoughts on the measure. Hearing none, we're ready for public comment in Sacramento.
None in Sacramento.
Thank you. Moderator, we're ready for public comment via WebEx.
This is the moderator. If you would like to make a comment, please click on the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments. I turn the floor back to you, Chair.
Thank you, moderator. Moving on to our next measure, Senate Bill 1347, Pupil Health Emergency Stock Albuterol Inhalers. Members, existing law allows schools to stock emergency albuterol inhalers and permits school nurses or trained volunteers to use them to assist individuals experiencing respiratory distress. As amended, Senate Bill 1347 expands that program to include child care programs operated by or contracting with a school district, county office of education, or charter school. As we previously discussed, this measure's provisions appear only in the Education Code, which may limit pharmacies' awareness that they can legally dispense inhalers under these provisions. Consistent with the board's April recommendation, the board staff have provided technical amendments to the author's office to reference this authority in pharmacy law, similar to existing cross-references for emergency epinephrine and naloxone, Business and Professions Code 4119.2 and 4119.8. Adding a parallel provision in pharmacy law could help ensure pharmacies clearly understand their authority to furnish emergency albuterol inhalers to schools and child care programs. I've been advised that staff believe technical amendments will be accepted. This measure will be considered by Assembly Education Committee on June 17th. Members, I believe the board's current support position remains appropriate, and I welcome your thoughts if you have any. Hearing none, we're ready for public comment in Sacramento.
None in Sacramento.
Thank you, moderator. We're ready for public comment via WebEx.
Says the moderator, if you would like to make a comment on the assembly bill, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments, I turn the floor back to you, Chair.
Great, thank you, moderator. If there are no additional comments, we'll move on to the regulations portion. Members, all items including in the regulations portion of the report are for information only. As detailed in the meeting materials and associated attachments, the board has several regulations in various stages of promulgation. I do not intend to review each as the information is contained in the public materials. Since the agenda was posted, the board submitted the rulemaking file for 16 CCR section 1793.65 related to pharmacy technician certification programs to the Office of Administrative Law for final review on June 1st. At this time, the board has one regulation under final review, one regulation for which staff are preparing the rulemaking file, 6 regulations in pre-notice review, and 2 additional regulations for which staff are preparing pre-notice documents. Members, do you have any questions or comments about the regulations? Hearing none, we're ready for public comment in Sacramento.
None in Sacramento.
Thank you. Moderator, we're ready for public comment via WebEx.
This is the moderator. If you would like to make a comment on the board regulations, you may look for the raise hand icon at the bottom of your WebEx screen. Or if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments, I turn the floor back to you, Chair.
Thank you, moderator. Members, if you have no additional comments, I'd like to thank everyone for your time and participation before we adjourn today. And please watch the board's website for future meeting dates. I look forward to seeing everyone later in a couple weeks at the board meeting. Thank you very much.
Thank you, Jesse.
Thanks,
Thanks,
Jesse. Good
everybody.
job.